Well, hello to everyone who is just joining. We are going to give it a couple of minutes just to allow everybody to enter into the room. I can see at the moment we're already approaching 100 people. We're expecting to be about 5 times that. So let's give it a minute or two and then we'll commence. We'll commence at 8:32.
Quite a brave start to the day for everyone, isn't it? Not having your brain bump started, really.
I think it's a fun way to start the day, James. Are we going to get to, just while waiting for everybody to join, James, one of the cases that I know we're going to refer to is helpfully unreported, which is the Re-C case,
yes,
which not everybody might have to hand. Is it possible for you to send that maybe to, believe it or not, some people might not have that to hand, yeah. So would it be possible to send that to Danny maybe? And then when we're dealing with it, if anybody wants it, then maybe Danny could email it to them afterwards.
Yeah, and I think we were going to do a bit of circulating of notes afterwards anyway, aren't we?
Yes, sure, exactly. Exactly right. Yeah.
Try and make the Danny thing happen now. Good luck, James, going in.
Yes, thank you. So that's just one point of order. And what was the other one? Oh yes, we're also going to refer to the A and M case from Mr. Justice Mostyn this week, which isn't yet on Family Law Week, but it is on Bailey. So that's another one that maybe could be made available.
By me? I don't think so. I'll do the first one though.
I think.
All right. Well, look, I think we'll start now. We're the participants is sort of keeping growing up, but let's get on with it because obviously everyone will want to be desperate to start work this morning, I imagine, and I want to not be late for that. Just a few housekeeping things before we commence. As we're all used to now, please keep yourself on mute if you're not one of the speakers. If you would like to ask a question, please put it into the chat box. I can see some people are already taking advantage of that. We are conducting a seminar by Zoom, which is great because it means we get to use the Zoom filter, so you don't have to see how awful we look in real life, which is great. And if there are any technical problems, if you can't hear us, or if there's anything else, just send us or Danny Chapman an email and we'll try and work out what's going on. So we'll start. So hello and welcome to this 36th family seminar on child maintenance. I am Byron James, a partner at Expatriate Law, and I'm based in Dubai, which you can probably tell because it's not that cloudy outside. My firm works only in international family law cases, me in particular on the Middle East. I have an article coming out this week about the remarkable changes that are happening in Abu Dhabi, where the default starting point on child arrangements going forward for separating non-Muslim couples is shared care, which I think is pretty amazing. So look out for that. James Peary needs no introducing. He's obviously a star of family law and a resolution legend. And in my view, any seminar on child maintenance that doesn't involve him isn't probably worth listening to. So thank goodness he's here with us. Otherwise you'd all be logging off pretty shortly. Andrzej Bojarski is one of family law's leading arbitrator judges and a very technical financial remedy practitioner, and someone that I know judges appreciate a great deal. Oscar Smith has been described as a rising star, one to watch and a future leader of her family law, or so he tells me. Having joined Expatriate Law earlier this year, it already feels like he's been there for about 10 years, and I mean that in a good way, obviously. So thank you all for coming. So child maintenance. We actually unhelpfully changed the title of this seminar after Danny did the flyer, so I apologize for that. We're now calling it How to Get to the Right Number and Keep It There, which we think is a much more positive way of looking at it than just simply saying, is it fit for purpose? So I think we should start with CB and KB from 2019 and Mr. Justice Mostyn, where he said, and I quote, "I suggest that in every case where the gross annual income of the non-resident parents does not exceed £650,000, The starting point should be the result of the formula, ignoring the cap on annual gross income at 156. For gross incomes in excess of 650,000, I suggest that the result given by an income of 650,000 should be the starting points, with the full discretionary freedom to depart from it, having regard to the scale of the excess. So James, why 650,000 gross, which is 355,000 per annum net? And should somebody with 3 children really receive 88,750 net per annum, which is more than a district or circuit judge earns, incidentally, irrespective of their own income?
Yes. We could all think
Thanks,
of different
Andrzej.
ways of answering that question. I am pathetically adulatory of Mr. Justice Mostyn. I consider us blessed beyond measure that we are here at a time when his brain walks among us. And yet even I have times when I find his ways are a little more mysterious than I can fathom, a little bit like Bob Dylan in the gospel years. I'm not quite with you there, Bob. I just thought I'd take us back to the history of that, all being well, which I think might have popped up now. So just to remind us all, GW and RW was the start when Mr. Justice Mostyn, wasn't Mr. Justice Mostyn then, as we know, started to tell us how we should be using the formula. M&M, the Court of Appeal, took him up on that on a Swiss case and decided pretty rigorously to apply the formula, which was interesting. And then we had TW and TM, where we were told that we should start to use the formula above the cap, just applying those formula numbers all the way up to this, beyond there. And then if you got very high, perhaps you should stop doing it. And then finally, we had the case you just mentioned where Mr. Justice Mostyn suggests that there's a cap on that. Now, I have problems with that. And I suspect that we're slightly trying to infill for a system that is intellectually toppling around. For a start, you might say, isn't that an impermissible gloss? We've got a Schedule 1 of the Children Act, which tells us what we should take into account. It doesn't tell us that we should slavishly apply ourselves to the formula. How can you say that provision should be the same, whether it's to a millionaire or to an impoverished student? If a person has 3 children with 3 different fathers, they get 60 grand from each, but the cost of maintaining 3 children from the same father are only 100,000. Why are we hitching ourselves to the terror of the CMS, which has a sort of glib clarity to it? But if you move into the world of international income, or if you move into complex assets, the whole thing is completely incomprehensible. I will be talking about a chalet if you give me a chance at some point. My bigger worry really is about how low do you go, or how far do you go? My experience is that most district judges aren't incredibly adept at working their way around the formula. Do they know what variations are? Would they be able to apply them even if they did? Do you take into account school fees? Do you actually look at the historic income, or do you look at what you think the income is going to be? I think this idea about a judge having to apply a set of rules that were not designed for the courts is troubling, really. We've also got this huge problem with the difference between Schedule 1 and MCA, which I think we're going to come to. And I am going to finish in a minute, honestly. We've got this schism in Schedule 1, and I don't know anyone's commented on it yet. On the one hand, you've got the sort of, and where have we seen this about impressions before, we've got the formulaic Mostynian approach of just put in the formula. But then you've got that whole sort of backdrop of cases, I could show you if we could be bothered, sort of in re the Antonio v. Rocco case, where the budget is centre stage. Why do you need a budget if all we're going to do is apply the formula? It doesn't really make sense. We also then have lots and lots of chat, Horowitz in particular, around the carer's allowance. But why do you need a carer's allowance? Why is the receiving party's income in the least way relevant if all you're doing is applying a formula? I've stopped.
Yeah, well, Andrzej, so I know, Andrzej, you possibly disagree with me about this, but the tension that James just referred to there could be articulated by the difference between, say, Mr. Justice Mostyn's decisions in A&M, which was out this week, and CB and KB, where you are saying you just apply the formula to income under 650,000, and you don't use spousal maintenance as a safety net via a nominal order or otherwise. But then on the other hand, which is very formulaic, as James says, but on the other hand, you have A, B, and CD, which is a decision of Mr. Justice Roberts, where Alexander Chandler tried to undermine the use of Siegel orders, where you have a global order. So irrespective, it doesn't really matter what's being applied between child and spousal maintenance. You have a budget, you have a global order, and you've got to meet the budget from the global order. I think there's a potential tension between those two things, but what do you think?
I'm not so sure about that. I mean, I've read A&M, and until you mentioned the point that you just expounded today, I hadn't read it in that way, and it hadn't struck me that way, because it was a case where the parents had agreed the maintenance figure for the children, and the judge was dealing with on fairly unusual facts, because there's a lot of trust assets in the background of the case. So it's a fairly unusual case compared to the vast majority that are going through the courts. What he should do about spousal support, and the main thrust of the decision on maintenance was about whether there should be a safety net. And so I see his decision in A&M being pretty much a continuation of the direction of travel that Waggett and the cases that follow that have set out, in terms of the assessment being very clearly based on needs and then looking at the capital resources towards meeting those needs. So I don't actually really read A&M as having much impact on the child maintenance assessment side of things at all. But I may be wrong about that. Maybe that other people read it the way you do, and other judges pick up that cudgel and run with it in that way. But that's not quite how I read it. So I still think that most judges are going to follow the Siegel approach, which is endorsed, as you say, by Mr. Justice Roberts in A, B, and CD, just because Siegel orders are such a convenient way of dealing with maintenance in situations where trying to separate them out into child maintenance and spousal maintenance, with the various variations that then arise from a child maintenance scheme that can vary from year to year as somebody's income fluctuates. That's highly unhelpful for many parties, and parties frankly actually often prefer to have a global figure which is fairly predictable from year to year and ride it out. So at the moment I don't see that's necessarily changed things very much. But to go back to your question you asked James to start with, in terms of where the 650 comes from, I mean, the decision of CB and KB is strange, isn't it, in many ways when you read it compared to other authorities, because of the language that Mostyn uses. He doesn't try and in any way explain where that £650,000 figure comes from, which is itself unusual for him as a judge, and unusual for any judge actually when they give guidance like that. And also he uses curious language. He talks, the passage you've read, he twice used the word "I suggest that," and although some judges seem to be reading, or some lawyers are reading, as if it's cast iron guidance, I'm not sure that all judges are, and I'm not sure it was necessarily intended to be a binding ratio within the decision. But in terms of where he has got the number from, I think it looks to me like he set a range for the upper end of what maintenance will be, which is basically for one child about 60,000 a year, about 5,000 a month, and at the upper end about 100,000 for 3 children or more, before you apply any sort of non-resident discount. So I think he's reached the 650 by just saying, well, a fair range, depending on how many children you've got, starts at about 60k a year, and it rises in £20,000 increments to £100,000 a year if you've got 3 or more children. And that seems to be in line with the sort of anecdotal figures that I'm conscious of that are often awarded in the larger money Schedule 1 cases, or at least a few years ago were being awarded by way of maintenance awards in Schedule 1 cases. And I think that's probably where his thinking has been derived from, and that's where the number has come from. And why has he done it? It's because he wants there not to be a significant difference between the statutory scheme, which the vast majority of cases are set by, and those few cases that are outside the statutory scheme. I can perfectly see why that's a sensible way of going about things in order to get simplicity, but I do struggle to reconcile that with what the 1991 Child Support Act provided for by Parliament, which says specifically that the statutory scheme goes to 156k, and then after 156k, the court has a top-up jurisdiction, which is entirely discretionary without any formula being applied to that. So why the judges have decided to say, well, despite the fact that Parliament said the statutory formula doesn't apply beyond 156,000 a year, we are going to apply it, I still struggle with. And I would hope the judges do continue to show a little bit more discretion than Mostyn perhaps suggests that they should. So that was a rather long rambling answer to a more straightforward question, but those are my thoughts on that.
Well, Oscar, so James referred to there being a schism between the Matrimonial Causes Act and Schedule 1. And I think what James means, and he can correct me if I've got it wrong, but we have a situation now where under the Matrimonial Causes Act, if spousal maintenance isn't a relevant issue, then child maintenance will be dealt with just by way of an application of the formula. So query, what if Kirker 15% of a net income isn't sufficient to meet a child's budgetary needs? But then under Schedule 1, it is outgoing schedule driven, and you have a completely different way of approaching the question of what child maintenance should be paid. So what do you think about that schism?
Well, first of all, I just want to reiterate James's appreciation of Mostyn's guidance in these cases, because it gives all of us practitioners a place to start with in these higher income cases over 156,000. In terms of the interaction between the MCA and Schedule 1 and how child maintenance is dealt with, I think inevitably when you have the ability to have spousal maintenance as well, you obviously have another door with which to receive some money. And so you inevitably have a slightly different situation for Schedule 1, but I think you need to split the Schedule 1 cases in two, because if you've got a CMS jurisdiction Schedule 1 case, quite often in those circumstances, you end up with the receiving party actually quite badly off, because there isn't the ability to get any carers allowance, there's no top-up order, there's no spousal maintenance. And I think nowadays there is still the, we see mothers tend to still do the majority of the childcare. And so it's adversely impacting kind of lower income single mothers. And it really highlights the need for some sort of reform in terms of cohabitation. Whereas if you have a top up or a case that's outside the CMS jurisdiction, an international case, you have a bit more scope to make sure that it's more needs driven, as you say, more budget and needs driven, and to move away from the starting point that Mostyn gives us of applying the formula. There are arguments to go over and above that if necessary. So I do think that there is need for the law to be looked at in this area. It's not satisfactory at the moment.
James, isn't the problem with the schism that you're in a case where a child, and this is the point I was trying to get at earlier with the tension, in a case where a child's needs aren't met necessarily, budgetary needs aren't met through just a pure application of the formula, aren't you then using spousal maintenance as a form of top-up in those kind of cases, in a way that in Mr. Justice Mostyn's decision this week, which was A&M, and also arguably by his application of the formula in CB and KB, you're specifically not supposed to do?
And I think you're onto something which is really interesting, that you know, it may be that we're on the start of squeezing spousal maintenance in a really profound way. We'll circulate this calculator later on in case anybody wants to play with it. But what we've got in here is somebody with £700,000, 2 children. So we know that if we go to the CMS, we'll get 20,000 and a bit if there were no overnight stays, which is 10 grand per child, which currently feels relatively normal. But when we move into the uncapped formula, you end up with numbers that I've never seen. I think the biggest I've heard of in child maintenance terms in an MCA case was Paul McCartney, wasn't it? I think it was 40 grand. So what I'm trying to articulate, and I'm not doing a good job on, is that Schedule 1 numbers are a completely different quantum from MCA child maintenance numbers. And we're treating them as if they're not. We're getting cases guidance handed down as if child support rules apply across the board. If we had tried to explain why a maintenance number was different in an MCA case and a Schedule 1 case, I would really struggle. I mean, I'm like you, I reckon people kind of throw out, well, 15 grandish per child, really, for somebody fairly well-resourced. I think you get up to 25 grand if you sort of push it. But we know that in Schedule 1 cases, it suddenly soars upwards, doesn't it? And that's really reflecting the fact that we don't have cohabitation provision. We realise that needs in some cases are bigger, and we don't have an ability to infill otherwise in the never married case. So I'm just wondering whether what these little points, these straws in the wind are heading towards is the idea of child maintenance soaring upwards and of spousal maintenance, which is the thing that we give all our attention to in our MCA cases, starting to decline and erode. And of course, at the moment, what we tend to do, particularly in big money matrimonial cases, is to suppress the level of child maintenance, because what we want is a punchy spousal number to put through the Duxbury calculations to get a punchy lump sum. And I think we're entitled to be confused because I don't think it's intellectually clean yet. I don't know if that answered the question.
Yeah, well, it does, because the problem at the moment is you have the capacity, don't you, to have either child maintenance being way too much because it's formula driven and irrespective of the other person's income, or insufficient because it's one size fits all and doesn't accommodate specific needs. So Andrzej, I'm gathering from your answer before, you just think this is something that you could easily navigate, and it's just a matter of persuasion and particular cases and applying facts to these things. Is that fair?
I think judges still apply a fair bit of discretion in these things, in my experience of those cases where they've come through. I mean, for the reasons that James has articulated, I think that the sort of oddities that sometimes are thrown out of applying the formula strictly, particularly once you go beyond the 156k cap, judges do tend to try and find ways of ironing those out. Though it remains, I mean, there do still remain slightly sort of aberrant aspects to it. I think James is probably onto something in terms of what he sees as being the sort of direction of travel of the law. That, you know, we can see the way spousal maintenance is being curtailed and curtailed, probably to bring the English jurisdiction more into line with that applies in many other jurisdictions, and putting the focus onto child maintenance and needs around that. So that may well be the way we're going to see things go over the next 4 or 5 years. Which of course is chaotic, isn't it? When you're ignoring the recipient's resources. Yeah, but I mean, those of us who are slightly older just will remember that the problems that existed when, well, before we had a statutory scheme at all, it was all discretionary, and that of course creates costs. It's good for lawyers, of course, because everything needs to be litigated, and then you get a Rolls-Royce bespoke service. The first iteration of the child support scheme was far more complicated. I mean, it was like a long physics equation with a lot of different parameters. We looked at both sides, and we all remember then the resulting appeals, because the more parameters that go into the calculation, the less certainty there is as to whether that calculation has been done correctly, the more scope there is for a challenge to it. And the original scheme for that, it choked under its own complexity. And the third iteration, which is the one we're now under, is a much simpler scheme. It works probably okay in the vast majority of cases. We're talking about those cases that are at the fringes, and inevitably any scheme that's designed to be simple for the vast majority of cases tends to be more difficult to apply around the edges. And I think that's, you know, that's the real point we're grappling with here, isn't it?
Around the edges is obviously where most of us tend to exist, right? Because that's why we're required. And so I agree with you that it's simpler than previous iterations, but isn't one of the great problems with Mr. Justice Mostyn's decision, respectfully, is it is an oversimplification, isn't it, of what the rules actually are? Because James, I know that some people, probably me, describe the CMS rules as being opaque. They're very difficult to interpret. They're often ineptly applied. They're very difficult to challenge. So when Mr. Justice Mostyn says, well, what you do is you just apply the formula, obviously he means the CMS calculation, and therefore all of the rules which apply to CMS calculations. And do you think that it is as straightforward as just going, well, it's nights, you have your percentage, you deduct nights, and then pretty much off you go? Or is there more scope for the rules to be more complex than that?
Yeah, it's horribly complex, and in a way, I think you're touching on two questions simultaneously. The one is the capacity of the child maintenance system to deliver something in any way that's sensible.
Yeah.
Pause. Let's just remember this was actually written by somebody who used to run Direct Line Insurance, or that was the person in charge at the time. The system was designed to be so simple that the flaws would be eroded, would be sucked out of it. So it wasn't designed to get to a good outcome. It was designed to get to an outcome that actually the people in the CMS could deliver on. But the other part of it is this whole thing around jurisdiction, which is, it's fine if we can sit in front of a judge and say, well, actually, we've got this problem in this case, please give me an outcome. Or it's fine if we can negotiate an outcome and actually have an outcome that sticks. Back to your title, that you can't have outcomes that stick without a Christmas order, which we might come to. But the real problem is that can you actually even access the court at all? And the answer to that is no. We were trying to have this regime, what Charles J said, well, actually, I think if the court decides that you're going to be a top-up case, then come on in. And then Mr. Justice Holman in Dixon and Rennie said, no, you can't. Effectively, the court's approach is to defer in jurisdictional matters to the CMS. The CMS decides whether a case is top-up or not, which is sort of fine if you've got a tax return last year that's enormous. But a lot of people don't have that. A lot of people with very significant wealth have very small numbers on their tax return because they are able to access very complex accountancy advice. And the consequence of that, of course, is that you're stuck outside the court. The court door is locked until you have a maximum assessment. And that is sort of catastrophic in the Schedule 1 case, because you might have been living a millionaire or multi-millionaire lifestyle, but unless you can show the tax return that backs it up, the court doors remain locked. Now, if you think about the sort of coercive controlling relationship, do stop me if you think I'm meandering off into something you don't want to know about.
No, we're moving on to domestic abuse now. So yeah, helpful.
Well, in a difficult relationship, how do I get the support that I need? So let's go back to my little calculator again. So if instead of the 700,000 of income on the last year's tax return, it's £100,000 of income, what I've now got is a range of payments as the recipient of what, £800 a month, a week? Sorry, a month, yeah. So it's a bit short of 10 grand a year, which isn't going to do anything. So you say, well, that's all right, you can go and apply for rent, can't you? Well, no, you can't, because rent is maintenance, and maintenance is I have to get from the court, from the CMS, and I can only go to the court once I've got a maximum assessment. So I think we've got major problems in the way this system works. And what I find so frustrating is that the courts are deferring to this system, which is hopelessly bust. And it decides access to the court. And access to the court is very, very troublesome. So I think Michelle Coonley is on this call, and she will probably explain this better if anybody wants to contact her. But this was a map that she and I wrote of trying to explain the way through the CMS process. And you can't see it, but we'll circulate the notes. But the idea is that you start up here in January, and it moves quite quickly. You might actually have your assessment in late February. But in this case, the late assessment is just going to refer to £100,000 on the income, and it's just going to give you 9 grand. Well, we know he's got assets, resources, and he's hiding stuff, and it's all sorts of things going on. So we put in our appeal. Well, the appeal is going to come up probably after 3 years. I mean, what we're experiencing now is that if you want to appeal the decision of the CMS, it's going to take you that sort of period. So for all that time, the court doors are locked. Now you say, well, that doesn't matter. We'll be able to it's just cash flow, isn't it? Well, it's not just cash flow, because eventually, yes, when I prove that it should be a maximum assessment, I get my arrears, which might be a kind of a windfall of about £14,000 if I move from my £100,000 number to my maximum number. But the real problem is I can't go to the court in all that time. And I can backdate my child support application maybe 6 months, maybe not at all. And of course, given that we've now been playing this child support game for the last 2 or 3 years, the paying party is going to have completely armor-plated their financial situation to make sure that we're probably not a maximum assessment anymore. So the trouble that we've got in some of these difficult cases, and we can think about all sorts of outliers. We can think of outliers where the paying parent is massively overpaying. But I'm just sort of focusing on the one where it's a license in the never married situation for somebody very well resourced to pay very low sums and actually to generate child poverty in consequence.
Yes, well, and also you mentioned domestic abuse cases there, James. For, I would say, most, if not all, victims of domestic abuse, time is extremely important. And so, Oscar, what would you say about any emergency powers under Schedule 1 of the Family Law Act 1996 that can extricate somebody from such an abusive situation? And that's obviously bearing in mind the Nwogbi enforcement problem of Section 40.
So I think James touched on some really important points then. And I think he's right to focus on the recipient of the maintenance rather than the overpayer, because ultimately we're talking about potentially child poverty, as he outlined. In the domestic abuse case, obviously under the Family Law Act, you have the standard range of injunctions available to the parties. And I think you also need to be a bit creative. So in a Schedule 1 case, obviously, if there is a property which is owned, there, and obviously as well, if it's a rental property, if you have a right to live there, you can get occupation orders and things like that. But if you are a beneficiary under the property, you can apply under Talata, for example, under, I think it's Section 13, 4 or 5, and you can apply for the beneficiary to pay outgoings on the property. So it's another mechanism to ensure that you, and you can do that in a relatively quick way. It's a way to ensure that outgoings are being met and your income needs aren't too, well, there's another access to a bit more money there in these Schedule 1 cases. I also think if you can get the maximum assessment from the CMS, you can also make an application under Schedule 1 for interim periodical payments and apply for LASPO at the same time, which typically it's the same, I guess, as making or similar to an MCA claim where you're making interim maintenance and a LASPO application. But that's all predicated on the basis.
Good luck getting an urgent hearing on that.
Well,
I mean,
and this is the problem.
One of the great issues, isn't it, is that we have these gatekeepers of getting in front of a judge who make decisions about the merits of the case and the merits of the urgency of the case without a judge even seeing it, which is quite frustrating.
And I think that's why it needs to, you also need to be off the back of one of those injunctions under the Family Law Act to give the matter some urgency, to try and get the matter before the courts, because, and James raised the point of how long it takes through the CMS appeal system. You know, how long would it take to get an order under Section 13.5 of Talata to get the beneficiary to pay outgoings? It's going to take some time. And I guess the other, if you are able to afford, you know, to instruct people like James, Peary and Andrzej on your case, you're in a very lucky situation. But most people we're talking about who are, you know, if income is being presented in a way which is much lower than reality to the CMS, you're not going to be able to afford the quite significant legal fees to take these actions. The other point I wanted to raise under Talata is it can also be taken into account if someone has not paid the child maintenance that's due and there are arrears, that can actually be taken into account into the division of equity in the property. But again, this is a very long-term
remedy. A long-term remedy and not going to help you in the immediacy.
Exactly.
So, Andre, going back to some more mechanical points with child maintenance, do you think that there is, at the moment, an underappreciation of the 12-month rule and the significance of receiving child benefits? I mean, I did a case last week where the other side took a lot of persuading that actually in a case where the paying party was due to retire in 18 months, that having an undertaking rather than a child maintenance order was actually to their benefit as the receiving party. And it didn't really seem to occur to them until said persuasion had taken place. So do you think that there is an underappreciation of that? And what would you advise for people to bear in mind with those things?
I mean, I think lawyers are conscious of it. I mean, I think lawyers probably are aware of it. I suspect that parties probably are not so much. So even when they're told it's the case that they can go to the CMS, I'm often surprised by how many cases that come back, usually at the variation stage on a maintenance order, sometime after an original order has been made, that you speak to a party and you point out to them the fact that they could have gone to the CMS for a reassessment after 12 months and they haven't. And even though I'm fairly sure they must have been told at the time, for whatever reason, they just assume, well, the order's in place. The only way I'm going to be able to change that is by going back to the court, and I can't afford to do that. James might have some more anecdotal sort of views about that. I know you mentioned Christmas tree orders earlier on that he might want to refer to as a way of getting around it. So, yeah, I mean, anecdotally, I think you're probably right. There is probably an underappreciation of it. And I don't entirely always even understand why the rule is there. It wasn't there in the original scheme. I think it was introduced later on. I think James will probably recall better that, but I think it appeared in either the second or the third iteration of the scheme, because prior to that, you had the option of effectively opting into the court track by an order by agreement, and then you were in that track until the court discharged the order, or one of the automatic qualifying reasons for a child maintenance assessment arose, which was normally somebody going on to benefits and therefore triggering an assessment through the CSA. But the opt-out wasn't there voluntarily, or not necessarily wasn't there automatically after 12 months. They then introduced it, presumably with a way of allowing people to have a more cost-effective way of varying the order. But it often works to the disadvantage of the payee, because often it's the other party who can stretch their affairs in such a way that they can reduce the amount of money that they pay by way of an assessment after 12 months. I mean, Jane may well have some more.
I'm going to ask James a question on that in a minute, but isn't the answer to your question because they don't want people going through the court dealing with child maintenance, and they want as many people going through the CMS.
But if the parties agree to opt into that scheme, then why give them an automatic opt out of it?
Because you can give. Yeah, because then they could opt out of it and go through the CMS after 12 months.
Yeah, but that's the bit that I don't fully understand. I mean, I think creating a system where you take the track and you take one track or the other track has some merit to it. But I agree with you. I think that the policy of Parliament and the government behind Parliament is to put people on the CMS track as the default, and that's why the 12-month rule is there. That do you default back to it after 12 months?
Yeah, it makes the court order a hiatus from the CMS rather than an alternative. But James, what I was going to ask you about this issue is, of course, the impact of awards obtained internationally that people seem to not quite cotton on to. What's the ability of the CMS to overturn those?
It's perhaps quite niche, but I've just experienced it a couple of times when people come in from other parts of the world with quite punchy maintenance orders. The family relocates here, and then of course an immediate application can be made to the CMS. You don't have to wait for 12 months. You can put it in immediately because the Act defines what is a qualifying maintenance order, which of course is only, mostly the English and Welsh statutes, and so any older made abroad doesn't count at all. It doesn't give you any protection. I mean, but just going back, God, this is so interesting, isn't it? The reason why we've got this 12-month rule was dogma. So I remember some quite feisty meetings between Nicholas Mostyn QC, as he was, and Baroness Hollis fighting over this very issue. And it was decided that there should not be discrimination, that people with money should not have the option of the, court system. That she intended us all to be dragged kicking and screaming into the CMS scheme, however pants it was, which is kind of interesting because when you then move forward a few years and everyone recognised the CSA was imploding, the new strategy was to remove all cases from the CMS as it's become. So what we've ended up with is a situation where we have the old policy scheme of forcing people into the administrative system, but the new administrative system, which is trying to lower the portcullis and stop anybody from going there, which is why you have to go through CM options. You have to try and persuade a bureaucrat that you should be allowed to go to the CMS now. So just to be clear, we've had a 180-degree turn of policy, but we've still got the old rules. Not surprising, it's a bit mad.
Now, Holly Warren has asked a question, and because it's about international issues, I think it's really interesting and I'd like to answer it. So if the paying party is overseas, would the court still consider applying the CMS formula as a starting point and the top-up guidance in CB and KB? So I would say, very quickly, that one of the great problems with people based abroad is that they're quite often paid in a different way to people based in England, which then means that the test of what does your P60 say is somewhat redundant. And we spend a lot of time looking through the very exciting Income Tax Act and trying to work out what is income, and does that include things like bonuses? The answer is yes. Does it include things like housing allowance? The answer is maybe. Does it include things like expenses? The answer is probably not. But these are all discretionary points that I don't think was necessarily envisaged when the court is looking to apply the formula to people who are based abroad. Because the other thing to remember, of course, is that in the area in which I live in the world, there are a lot of tax-free regimes. So therefore, what is the relevance of gross income? So some people approach that.
I've had those cases, Byron. What I've seen, I mean, we both agreed orders in this basis, and I've also seen a couple of judges do it on this basis, is where somebody is in a non-tax paying regime. So effectively all the income they receive is net. That figure is grossed up to make it an equivalent figure for
which I disagree with.
Purposes. But I've seen judges do that.
Yeah, and I think that's wrong. I think to ascribe somebody a gross income that they don't have is not correct. I think the correct way of doing it is applying the old formula and going on a net income and using the formula to apply to the income they actually receive. But
have you seen a judge do that? Have you ever persuaded a judge to do that?
I think we may have persuaded you to do it on an arbitration once, but maybe I'm wrong about that. But that is confidential information, so we cannot discuss that anymore.
The reality is, I mean, you're right. I've seen cases where they've grossed it up, but they've then taken into account things like allowances that are paid that are unique to that jurisdiction, and they've also taken into account the extra living costs that somebody who's living in an expat situation may have compared to somebody that's over here. So I've seen judges use the starting point figure using the gross figure, but then apply a lot more variations to it to take into account the specific circumstances to arrive at a figure that they felt was fair.
But what often ends up happening in those cases, it becomes budget driven, because obviously what then matters is the budget rather than what the CMS formula meant to be applied to people paying tax and living in England produces, rather than somebody, say, living in Dubai who doesn't pay tax in a completely different outgoing system. So for example, in the UAE, you don't have public healthcare, you don't have public schooling, you have to pay privately for all of those things, you have extra needs for children, which arise from those things. Anyway, well, thank you, Holly, for that question. I appreciate being able to answer it. So going back to the application of the rules, Andre, to calculations, what about Regulation 50, which sounds somewhat ominous, but what do you think? So if we're applying the rules strictly, should there ever be a child maintenance order where there's shared care?
Yeah. Okay. So Regulation 50 is the Regulation 50 of the Child Support Maintenance Calculation Regulations 2012. And what, in short, it does within its various subparagraphs is it creates a starting point presumption that the person who's in receipt of child benefit, or who would be in receipt of it if the parties weren't over the high income eligibility threshold for it, is the person who provides day-to-day care to a greater extent than the other person. So it presumes that that is the position in terms of who the payee and payer will be. But that presumption can be rebutted, because it's a rebuttable presumption within the regulation, by any evidence that shows that the person named in the application as the non-resident person doesn't provide care to a lesser extent than the applicant. Now, this creates something of an anomaly, because for the purpose of the normal discount, you look entirely at, so the normal shared care discount, the 1/7, 2/7, 3/7 discount, that one looks only at overnight care. But for this purpose, which in some ways is much more fundamental, because this ultimately determines whether there is going to be an assessment or not, the regulation has been defined or interpreted in a number of decisions, both at the first tier tribunal and at the upper tribunal, as requiring a more holistic assessment of what care means, and not just looking at overnights. So, and they've also been clear that the child benefit provision is only the presumption. If there's any other evidence that shows what the actual care arrangements are, that evidence is what the court needs to look at, or the tribunal needs to look at, rather than just looking at who has the child benefit. So we have a situation which is slightly more complicated than I think many people realise. And James may correct me, he may have better knowledge of this, but all of the cases that have dealt with how this applies so far that I've seen have not actually answered this question, which is, if Regulation 50 applies and the court takes the view, or the tribunal takes the view that this is a pure, exactly equally shared care arrangement, so there is no liability for maintenance, is that a case where the Child Maintenance Service doesn't have jurisdiction? Or is it a case where there's a nil assessment, whether there is jurisdiction, but the CMS has taken the view there's a nil assessment? And why that's an important question is pretty obvious, because if it's a case where the Child Maintenance Service has jurisdiction, the court jurisdiction doesn't exist. Whereas if it's a case where there's a nil, sorry, I'm confused myself in terms of what I was saying there. If it's a case where there is a nil assessment, but there is jurisdiction, then the court won't have jurisdiction. If it's a case where the CMS does not have jurisdiction because there is no resident or non-resident parent they can define, then there is the scope to go to the court under the provisions of the Child Support Act. And I don't think that question has been answered, but James may actually have seen something that does answer that. But that's pretty fundamental. And I don't think has been properly challenged by anybody or used by anybody yet to see whether this is actually a way of opening the door to more cases being assessed by the courts, rather than being dealt with through the statutory formula.
Yeah, the way we're doing it at the moment is you apply to the CMS, they tell you to get lost, you attach that to your Form A or A1, whatever you're doing, and you run from there. But you're right, we're simply assuming that if you're in shared care, which of course is different from shared care band equal, really. If you're proper Regulation 50 shared care, then you can go to the court. But there's also, and that's why there's so much tactical stuff around child benefit, because if, do you want, you have to think about whether your client wants the protection of the CMS or not. And that might inform as to whether they're going to rush to secure child benefit, because we all know jolly well that once the CS officer sees that somebody's claiming child benefit, they'll then say, all right, they must be the parent with care. And if you don't like that, you can make the appeal and we'll see you in 3 years. So there's all these opportunities to move into the sort of unregulated Hobbesian jungle. And I suppose to answer Andrzej's question, what it would take is for somebody to make that application to the court, wouldn't it? And then the court make an award, and then someone challenge that jurisdiction, and then it go up on appeal. And
yeah. I'm surprised there hasn't been a decision yet, because I think a lot of it's usually the payer has tried to get themselves into the Regulation 50 situation so that they can have a nil assessment and not have to pay maintenance. and perhaps not realizing that that can actually be a bit of a Pyrrhic victory because it opens the door to the other party making an application to the court. But I've yet to hear of anybody who then, when that other party has made the application, saying, well, actually, the court doesn't have jurisdiction because this is a case where the CMS has carried out an assessment but said it's nil.
And of course, the fascinating thing then is what you do next. So if you pick up the book of Mostyn, it would say, will you do what the CMS would do? Hang on, the CMS has just told us they don't want to talk to us.
Yeah.
Get around in circles.
Exactly.
But it seems to me that given that the CMS would, if it wasn't shared care, but instead it was shared care band equal, which just basically means you have 174 nights plus, you get 50% of the award you would have had, less £7 per week.
Now we're entering the last 10 minutes of the seminar. So if anyone has any questions, please put them into the chat and we'll try our best to answer them before that 10 minutes expires. Oscar, we now know that a middle-aged solicitor cannot compel his parents to provide him with financial support into his 40s from FS, RS and JS, which is presumably bad news for some of the audience. What financial support is available, though, for adult children in educational training?
Well, under Schedule 1 of the Children Act, there is scope for adult children to make applications for financial provision for themselves for their education and training. So obviously you're looking at things such as paying for tuition fees of university and the costs of doing some sort of training scheme and things like that. So that has to be an application made by the child itself rather than by the parent, because once the child is outside of the jurisdiction of Schedule 1 for the parent, then of course the parent cannot apply on behalf of that child unless they're a vulnerable adult, in which case there is scope for that. But you come to a potential issue for that adult child is that they may actually be prohibited from making this application because of a provision in Schedule 1, which is, I think it's at section 2(3), which basically says if there is a periodical payments order in place for that child at the point that they reach the age of 16, then they are unable to apply for this extra provision once they turn 18. So that means a young adult of unmarried parents could be in a position where they can't make the application themselves, and obviously the parent cannot make the application as the child is no longer a child. So you end up in a quandary.
I find that provision extraordinary, and Andre, I don't understand how that is Article 6 compliant. Because
I've never understood why it's there in the first place. I mean, I've never really understood the rationale for it. How
can you be effectively, because obviously after you're 18 you can't apply because you're outside the you're no longer a child, and if someone else has obtained a maintenance order for your benefit, and that prohibits you from accessing money that you need, how does that comply with Article 6?
I mean, I've always found it odd because and I've had situations where technically, of course, the person who held the order, so the parent, could still make an application within whatever provisions exist there. But I've had situations where, from the time when the order was made and after it's elapsed, and by the time the child has reached 18, they become estranged from both parents, and therefore neither parent wants to help them, and then they are left in exactly this situation, which they can't get themselves out of. And I just find it. Really
the alternative, of course, is if there is a bar. So that is an obvious omission, isn't it, from paragraph 2? Because it's all well and good. So I think what it means is you can't double count. So the remedy should be to extend the maintenance order that you've already obtained rather than get a new one. But obviously it doesn't envisage there being a bar at the child's 18th birthday, for example, at which point they're stuffed. There's nothing they can do at that point.
No.
Okay, well, we've got 5 minutes left. James, it seems a lot of people want to know about Christmas orders, and there's nobody better placed to tell us about them than you. Laura Mortimer, for example, says, what are your experience of them being upheld?
I think they are upheld if made. You'll never get one from Mr. Justice Mostyn, who says that they're an aberration and should not be allowed. I think it's the only way of actually getting the court to take control of a situation which, you know, parents have decided they want because they've agreed and they've sorted it all out. They want to have a rational system rather than have a litigation after party through the CMS for years and years. So very briefly, Christmas order, we all know that section 410AA says you can go to the CMS even if there is a court order once that court order is 12 months old. Or if there is no order, you can go to CMS. So what we tried to do was to create a chain of, like a paper chain, so the orders end on Christmas Day and they're a nanosecond less than a year. So there's never a moment where there isn't an order, never a moment when it's 12 months long. And I think it works. I've had one person contact me and say, this is an absolute disgrace. I can't go to the CMS. I've got a Christmas order. I'm going, yeah, that's kind of what they were designed to do. So,
James, I mean, I agree with you that they're upheld in the sense that the judges do approve them. I think that's what you meant by upheld. But have you known anybody who has tried to go to the CMS and been frustrated from doing so by the existence of a Christmas tree order? Because I think most parties play along with them when they've entered into them and they're happy to play along with them. But have you had anybody who actually after 12 months has said, this doesn't work and the order is now extinct and I can go to the CMS?
Yes, but I've not seen it fought out. And I don't think there's been a report on that. I actually think that, I don't know, it'd be interesting to see, God, all these cases that we're about to start running, it's terrifying, isn't it? And just to pick up on two more, if I could just very quickly, I'm interested about the idea about gap years. You know, if one remembers duration of orders, that you can obviously have support for a child once they're in education, or if there are special circumstances, how special is a gap year? So I think that's interesting.
Depends where you go.
Yeah, I suppose perhaps just.
You know, something to think. I mean, can I just raise one other sort of a slight anomaly that I came across in a case recently, which is the way boarding school fees are dealt with. So, if you've got children at boarding school, effectively they're going to be at school for 60% of the year and not living with either parent. And you would think that logically what the scheme would then do would make some allowance for the fact that they're not at home with either parent for that period of time and reduce the amount of maintenance proportionally. But that isn't how it works. Well, the way it works is that it deducts the fees that are the school fees from the paying parents' income and then carries out the calculation on the balance, which in lower income cases actually probably works okay. But when you start getting into the larger numbers, what that means is it makes a very little difference to the amount of payments that are made on what is potentially quite a large number, as James was showing with his calculator earlier on, if you're using the £650,000 cap. But the other effect of it is that effectively, because they are 60% of the time at school, they obviously can't be living with either parent for more than about 30 to 40% of the time, even if they're entirely living with one other parent, which means that you're never going to get more than something 1/7 or 2/7 discount, because you can't share care to the 156 nights a year because there aren't enough nights a year to allow you to do that. And I've always found that really odd that at least there is a concession made about it, but the way it's been done just seems completely illogical to me.
And it's clear who it would be. It's where the child would be if they weren't at boarding school, and that could be either parent, it could be the rich one.
Yeah.
Because mum's moved away to Devon.
Now, we started off in our pre-chat by saying that this could be a day seminar because there are so many things that we haven't talked about. There was so much more time we could have spent talking about these things. So this in many ways is a taster for a wider discussion, I think, on all of those topics. It's now the end of the seminar. We've finished on time at 9:30. Thank you so much for everybody attending. We really appreciate it. And if there's going to be an email, I think, from Danny Chapman with some notes using some of the documents that we've used in the seminar. So if you don't receive that, then please follow up with Danny and ask him. And obviously, if they have any questions about child maintenance in particular, I know that James and Andre are always whatever the equivalent of an open door is in email terms, that you may always walk through. Thank you so much. I wish you a lovely rest of your day, and you can get on and do your work now. Thank you very much.